Ever heard of a rule where if you miss a deadline, you automatically win your case?
It does sound a little unusual, right?
Yeah. Too good to be true.
Well, there's something called the 120-240 rule in maritime law.
Really?
And today, we're diving deep into a case where this very rule comes into play.
Okay, so a rule that can make or break a case. Gotcha. I guess that's why it's called a deep dive, right?
You got it.
Yeah.
And this one is a prime example of how, let's say there's some gotchas that can really trip people up when it comes to maritime injury claims.
All right, gotchas. So where do we even begin with something this complex?
Well, the core issue we're talking about is that being declared unfit to work isn't actually the same as qualifying for permanent and total disability benefits.
Interesting. They sound pretty similar, though.
You'd think so, right? But they're distinct legally, and this case really brings that home.
All right, so there's a critical difference there. I'm ready to hear all about it. But before we get into the legal nitty-gritty, who are we talking about here? Whose case is this?
Right, so we have Ramon, a hardworking guy, a messman on a ship, and he suffers a serious back injury while he's working.
Oh, no, that's awful. On a ship thousands of miles away from home.
Exactly. A tough situation all around. He's hospitalized, treated, and then eventually he's sent home. And that, my friend, is when the 120-240 rule kicks in.
Okay, so we're jumping right into it. This 120-240 rule, what is it exactly, and how does it affect someone like Ramon?
Essentially, think of it like a ticking clock. This clock starts the moment a seafarer, in this case, Ramon, reports an injury. The company appoints a doctor to assess the injury. That doctor has 120 days to make an initial assessment.
120 days, so just over 3 months, to see if the injury will heal completely within that time.
Exactly. That initial period is meant to figure out if it's a temporary thing or not.
Makes sense.
Now, if it's clear that more treatment is needed, they can extend that 120-day period out to 240 days. That's roughly 8 months.
Okay, so a bit of breathing room to recover.
Right. But here's the catch, the gotcha we mentioned earlier. If they don't make a final decision on the disability grade within that 240-day window,
Yeah, what happens?
things change dramatically.
Okay, you said dramatically, now I'm really curious. Lay it on me. What happens after that 240-day mark?
It's almost like a legal trump card for the seafarer. If that 240-day mark passes and the company doctor hasn't given a final assessment, the seafarer is automatically considered permanently and totally disabled, just like that.
Wow. It doesn't matter what the company doctor says after that point.
Nope. That 240 days, that's a hard line in the sand.
Wow. That is a game changer. So Ramon and the company doctor, they're on this 240-day timeline. What happens? What does the doctor say?
Well, at the 133-day mark, the doctor released their assessment.
Okay, so well within that 240-day window, what did it say?
The doctor said that Ramon had reached what they called maximum medical improvement.
Maximum medical improvement. So that's it. End of the road.
Well, that's what makes this case so interesting. They use that phrase, maximum medical improvement, but the doctor also gave Ramon a grade 11 disability rating.
And what does grade 11 mean in this situation?
It basically means partially disabled. Not totally, but partially.
Okay, so which one is it?
Well, that's just it. And this is where that gotcha comes back. The report, it didn't actually say how long it would take for Ramon to fully recover or if he ever would.
Hold on. So even though the doctor said maximum medical improvement, because they didn't clearly say how long recovery would take or if he'd ever be 100%, there's still an opening.
You got it. That's exactly it. And that's where this idea of final and definitive assessment really comes into play.
I'm starting to see how those little details, even just phrases in these reports, can suddenly have huge implications.
Absolutely. And in Ramon's case, it was a detail that sent his case all the way to the Philippine Supreme Court.
No way. The Supreme Court. Wow, this is serious stuff.
Oh, it is, believe me. And the thing is, their decision on this case, it set a major precedent, and not just in the Philippines, but for maritime law in general. And you know what it all came down to?
What's that?
That one phrase, that final and definitive assessment.
So the company doctor's assessment, even though it was given within that 240-day window, the Supreme Court still didn't see it as final and definitive. What didn't they like about it?
It's pretty straightforward, actually.
Yeah.
The Supreme Court, they agreed that Ramon had reached maximum medical improvement.
Okay.
But they said the doctor, he didn't actually connect that to Ramon's ability to work, in the future.
I see.
They said, okay, his back pain, it might be as good as it's going to get, but remember Ramon, he was a messman.
Right, a very physical job.
Exactly. Heavy lifting.
Right.
On a ship that's moving all the time. So the question is, even if his back is improved, can he actually go back to doing that?
Right.
In the doctor's report, it just didn't answer that.
Interesting. So it's not just about the injury itself, it's about whether you can actually still do the job with it.
You got it.
Yeah.
It's about your ability to work, your capacity to earn a living, and because the doctor didn't connect those dots, make it crystal clear within those 240 days,
Yeah.
the Supreme Court said, nope, not good enough, ruled in Ramon's favor.
Wow. That's incredible. So even though the company doctor had that phrase in there, that maximum medical improvement, it wasn't enough because they didn't take it that extra step and say, okay, and here's how it affects his ability to actually work as a seafarer.
Exactly. It backfired on them.
What?
And this is huge because it set a precedent. It tells companies and their doctors, you can't just use vague language. You can't just throw in a phrase like maximum medical improvement and call it a day. You have to be specific. You have to address the seafarer's future work capacity directly, and you got to do it within that 240-day window.
It's like they say the devil is in the details.
Right,
Yeah.
100%. This case really highlights how important those specifics are in these legal documents, especially when it comes to something as crucial as disability benefits. I mean, this is people's livelihoods we're talking about.
Absolutely. And it seems like this 240-day rule, it's really there to protect the seafarers, right? To make sure they're not stuck in limbo, waiting forever for a decision.
Exactly. They need that certainty, that financial security, especially when they've been injured and they're unable to work.
Right. They need to be able to plan for their future. So Ramon, it sounds like his case had some really significant and positive ripple effects.
Oh, absolutely. And it's not just about the legal precedent either,
Oh, what else?
It's about Ramon as an individual having the courage to fight for what's right, and in doing so,
Yeah.
he changed the game for everyone.
It's a real David and Goliath story when you think about it.
You said it. One person standing up against a whole system.
And it all goes back to what we always say, knowledge is power.
You know it.
But I think even when you do know the rules, it can still be really overwhelming to actually navigate them, right? Especially in a situation like this.
For sure.
So for anyone listening who might find themselves in a similar situation, what are some of the big takeaways here? What should they know? What kind of questions should they be asking? It's true. It can feel overwhelming. You're injured, you're far from home, and then you've got to deal with all this legal stuff, these deadlines, the jargon. It's a lot.
Absolutely. And that's why I think the biggest takeaway from Ramon's story, the thing everyone needs to know, is this 12240 rule.
This 240-day clock.
Yeah, exactly. And the thing is, it's not just some random legal thing. It's crucial. It can make or break your claim.
So knowing about that is priority number one. What else can seafarers do to make sure they're protected?
Honestly, don't be afraid to ask questions. If something in that doctor's report seems off, or if something's missing, speak up. This is your health we're talking about here, your ability to earn a living.
That's such a good point. Sometimes you're just so relieved to be getting treatment, you forget to really advocate for yourself, to really understand what's going on and what it means down the line.
100%. And if you're still feeling unsure, get a second opinion. Talk to a different doctor, preferably one who specializes in maritime injuries. They can help you connect the dots, explain how your injury affects your ability to work on a ship specifically.
Because that's crucial, right? Getting that second opinion could mean the difference between being labeled partially disabled and being recognized as totally unable to do the job anymore.
Exactly. It's about protecting your rights, making sure you're getting the compensation you deserve.
Ramon's case is a powerful reminder that sometimes these huge decisions, these life-changing things, they hinge on the smallest details.
It's true. One phrase, one missing sentence, that's all it takes.
And that's what we try to do here on the Deep Dive, right? We break down these complicated topics, look at the details, the things people might miss.
It's about giving you the knowledge, the tools to navigate this stuff, because let's face it, it can be overwhelming.
Because at the end of the day, knowledge is power. And in this case, it could be the difference between feeling lost at sea and actually charting a course towards the justice and the compensation you deserve.
Couldn't have said it better myself.
Well, on that note, I think we've given our listeners a lot to think about today. This 12240 rule, this final and definitive assessment, it's all crucial information.
It really is.
Hopefully they'll never need to use it, but if they do,
They'll be ready.
exactly, they'll be ready.